Welcome to the second part of Gloria Ford's discussion of her son, former person of conscience, Kenneth W. Ford Jr. Ms. Ford, your son's in jail up in Pennsylvania. You literally, along with your husband, determined that you need to almost become your own Perry Mason and Johnny Cochran and every other sort of legal genius to try to make sense of what happened to your son. What steps did you begin to take after you took him up in April of 2005? What did you begin to do?
Well, the first thing was we wanted to file an appeal, which step one is to get the transcripts. And we had a hard time getting the transcripts, and even and to today we don't have the transcripts. We have altered transcripts.
Excuse me. You're saying for a federal trial regarding espionage, there is not an official transcript for the trial that you've been able to access?
Yes, we were told that there were 3,300 odd pages in the case. It seems that when you order the transcripts, you're supposed to get everything in the case, everything, from the time it starts, say the arrest, the search warrant affidavit, clear on up to the sentencing. And we were told motions and everything. We were told that by our attorney, who asked the stenographer what the cost would be, and she said it was 3,000 something odd pages at $3 and something cents per page, so it would be 6,900 and something odd dollars. We promptly wrote a check for the transcript, because we needed to get this appeal filed.
Did you get the transcript after you paid the
No.
$1,600? No. Did you get your money back?
No. So we paid the money to the attorney, and supposedly the transcripts hadn't been transcribed. They were top secret, this, that, and the other, so forth and so on. Finally, and this was in April of 2006.
If they knew it was 3,000 pages, how would they know that if it hadn't been transcribed? Doesn't that sound like that's two different stories?
Tell us about it.
So you are out almost $7,000, and then you discover after you've paid, the reason that you can't get what you paid for when you were given the amount necessary to secure the documents to file your appeal, that it had not been transcribed. Did you ever get a schedule of how long it would take for a jury trial to be transcribed? I thought stenographers, as they're typing, should be able to organize that information fairly quickly.
I know that for a fact.
So can you help me, as a person who is not a lawyer or a judge or an attorney or a stenographer, to understand if you have a 2-week trial, it's several months afterwards, and yet they had not organized the information even when money is available to pay for it?
Can you tell me to understand? So.
And it's been how many years since you paid?
Well, the sentencing was March 30th. We paid the $6,900 and something dollars in April, around April 21st.
2005.
Of 2006. The sentencing is in 2006, March 30th. And we paid that money, so we expect to have the transcripts. Our attorney is coming back to us. They don't have it, this and that, and the other. The prosecutor is saying one thing, this and that, and the other, so forth and so on.
And your attorney is still Mr. Hecht?
Yes, So we are waiting for the transcripts. 2006 comes and it goes. We're in 2007 now, and no transcript. So we go to court. We have now it is our belief now, several years later, that now our attorney at this point is in collusion with the prosecutor and has been for quite some time. It is our belief. So, we have this hearing, motion to get transcripts, which was a complete farce. And we go into the Greenbelt courtroom in front of the judge, the same judge, and I'll tell you about him later. And it was ordered that we get these transcripts. So finally, on November 1st, there appears in our mailbox. Now, mind you, Kenneth is in jail. He's been in there since 2006. Now this is November of 2007. Is that right? November. And on November 1st. And we get this envelope, and it's, in fact, this is a page from it. We get a stack of these. It's 4 pages. It's 4 pages to a page. So we're thinking that the attorney made this, and he has the traditional transcripts that one would pay for, bound, double-spaced, and we thought he made this. So come to find out, he said he didn't. That's how he got them. And in giving us these transcripts, I have 2 pages here, but there are blocks missing, whole blocks, and it says classified,
redactions
classified.
Within
the transcript
necessary to file the appeal.
Exactly. Exactly. And we saw that transcript that they had been altered.
So the transcript has been redacted and altered, thereby making it difficult for you to file an appeal. Did you win your appeal?
No. And we don't even know what appeal was put in, because our attorney sent us this brief, which we had a big roundabout, because we understand this legal mumbo jumbo. And this is not what we, and the appeal that he wrote was not what we signed up for.
So
and that appeal,
he filed an appeal.
He files an appeal
of his own volition. That was other than what you agreed to when you...
Exactly.
So as you retained him, you wanted one type of appeal, and he did something very different with that.
With different issues. The issues he filed on were watery, mushy, sappy, and just...
So instead of having an airtight appeal, he essentially undermined the appeal by picking the least defendable points for challenging the outcome of the first trial.
Exactly. And we told him to withdraw it. He told us he couldn't.
He could not retract his appeal. Did you retain him as an attorney, or did you decide to get rid of him?
Well, this is the appeal it's in. So it's into the Court of Appeals.
And you couldn't have an extension or some motion
according to
dismiss?
According to him.
There has to be some legal process by which, inasmuch as if they haven't gotten to the appeal, there should be some legal maneuver to say, since that's in the pipeline, it hasn't gotten before the clerk of the court to assign a trial date. That should be fairly easy to maneuver to pull that out.
That's what we told him, and we have emails not with us today to back us up. We're back and forth.
And his response to that is that there's just nothing that can be done.
Nothing can be done, and then it took a very, very, very long time.
How was your exchange with him? Did it seem respectful, or did you have the sense that you were being treated like maybe you pick cotton for a living or something of that? Do you have in any sense, you're a black woman and you're dealing with a white male, did you get the sense that people thought you're just black and stupid, whatever.
Oh, yes. And as a matter of fact, by the time we got to that stage, I would tell him, Spencer, you have changed. You have changed. And
What
then
was his response? Did he?
Mealy mouthy and I'm a forthright person, and I'll just tell you. And so anyway, as we go, this appeal, wait a minute, I think I need to backtrack. I think I'm a year off. We got those transcripts in November of 2000. Was it 2006? Because he filed that appeal in 2007. Yes, it was November 1st, 2006, when the transcripts came in the mail. So in October of 2007, he sends us this copy of an appeal, and it's stamped on the front page, that on the front cover, that it was filed with the United States Court of Appeals, Fourth Circuit, on October 16th, 2007. It takes 3/4 of the year. The Fourth Circuit has the shortest turnaround time of any. It's 9 circuits, I believe. Is it 9 or 12 circuits in the country? The Fourth Circuit has the shortest turnaround time, generally about 3 months. So we said, what's taking so long? What's taking so long? So it's one excuse after another. At one point, he even told us that, and he wrote down, we have the emails, it's in the clerk's office, and it's being reviewed for pre-oral arguments.
Pre-oral argument?
That doesn't even make sense.
Now, I need to ask you, if this same attorney prepared the defense for the trial before, shouldn't they have some authority and understanding what the case was about, what the problems were with the case, to have a basis for appeal? To say that there's a need for pre-oral defense means
I would think
as
so.
if he did not understand the very trial.
I would think so.
And the process that he himself was party to.
I would think so. But this is the kicker. The result of the appeal is issued by the Court of Appeals on August the 6th, 2008. And they said they are answering something that had been filed on June 26, 2008. That is their turnaround time. So what was filed on June 26, 2008? We don't know to this date, because what we have is stamped October 16, 2007.
Okay, so there's a possibility that there are 2 appeals in relationship to your son.
Or was the first one ever filed? I mean, anybody can get a stamp made up.
I understand. So possibly the appeal was not filed at all, and or a appeal was made to prevent the first appeal that was submitted from being done, and a second one that was even weaker, that was less compelling, was submitted with time for it to be worked on where it would be ineffective.
Exactly. And the first appeal, well, the one that we read, dated October 17th, 2007, the 3 issues he's appealing is, 1, the constitutionality of having classified papers under 793E, which is espionage. That's the law. That's a high school debate. The second issue concerned speedy trial. Now, the speedy trial issues were that they violated Kenneth's speedy trial rights all the way around the board. Now, what he failed to mention in his brief is that he had been cleared since June of 2004. And the brief and the answer centered on the fact that Mr. Ford, he kept changing attorneys. He didn't. And the third issue was the illegality of the sentencing by the judge. Yes, the judge did sentence illegally, but not for the issues that Mr. Heck had in his brief. So these are wishy-washy, mealy-mouthy, high school debating.
Appealing for legal redress for issues not that had no bearing to his case.
Exactly.
If I could say that like an attorney.
Exactly.
That's what you had. Okay, so you dismissed this attorney at some point.
Well, he's finished. We are finished. We don't have a good relationship. We're done. And so I said to my husband, I said, we have all this proof of what happened. By then we had lots of proof, but then we were to get more proof. And I said, we have this proof of Ken's innocence and being framed in all of this. But yet we're sitting here having lost the case, lost the appeal. We need to get to the bottom of this. And for the next few years, that's exactly what we did, which led to this letter that we sent to Eric Holder.
Could you quickly just tell me some of the things that you and your husband would do? Were you burning lots of midnight oil?
Yes. We would do research mostly on the internet. We went to the courthouse a few times. We have a cousin of mine, my first cousin, and she is a paralegal, and we got her involved. And she would look up legal precedents. We would look up legal precedents. I would work all day, come home, work on this until the wee hours of the morning. At least 3 occasions I have come home from work, worked on this, saw the sun come up, shower, and then go back to my job, working on this. I would wake my husband up 2 and 3 o'clock in the morning. Look, listen to this. Listen to this. And I'm reading this.
How many thousands of pages would you say you've accumulated? You have boxes?
Our house is Legal Central. We have boxes of documents, newspaper articles, books. It's a mess there.
Did you ever get did anyone ever just send you a letter, or did you ever just have someone say, I didn't give this to you, but this might help
No. Yes.
the right way? So
Yes.
you did everything the right way to amass this exculpatory paper trail.
Exactly. And my cousin helped tremendously in the legal precedents.
Okay. Let's talk quickly about Ken in the system. Now, you're a mother. That's your child.
That is my child.
Came out of you and your husband, the
Yes,
only
indeed.
child.
My only child.
And you went to visit him regularly?
Yes. At Lewisburg, there is a schedule, and you have to abide by the schedule, and it averages out to be once a month. And that is 200 miles one way, 200 going, 200 coming back.
How did it feel to see your son in prison?
It felt horrible to see my son in prison. And I would drive through the gates, and it said Bureau of Prisons. My son. And to go into a room, thank God it was an open room. We could touch him. And he's in a prison uniform. Exemplary person. You don't get those clearances just because you want them. You earn those. You earn them. My son. and I had 5 hours. We would sit there and visit. Then we would leave him there for years for absolutely nothing, for the criminals who work in the Department of Justice, so-called Department of Justice. Criminals. They need to be there. And I felt pain every single time we went. Every single time. And I don't wish this horrible situation on anybody. Not even the perpetrators who did this. I wouldn't want anybody to be framed unjustly. My son was framed. A picture was painted and he was put into it. Nothing happened. Nothing.
When you saw your son and you saw other people there, how did it impact your husband? How is your husband dealing with?
Well, my husband, he's bitter. He's bitter. And he wasn't like that at first. He's bitter about this. He has he has no trust in the government. I don't either. After observing this, I don't have any trust in the government. He's bitter, and he has a right to be. This is his child. And we raised him to be an honest and honorable citizen. And I'm here to tell you right now, the people who did this are not worthy to kiss his you-know-what. They are not worthy. And I'll name them. The judge, Peter J. Massetti, he knows it. The 2 FBI agents, Michael L. Thompson, Frederick C. Marsh, the Department of Justice Attorney Mary Claire Rourke, and the prosecutor, United States Federal Prosecutor David Ira Salem. They are not worthy, and they know it.
You've mentioned several people who are within the justice system who not only not delivered justice in the case of your son, but have brought considerable hardship and difficulty to your family. If you could bring life to the name of what it is that even in short data bits for people to understand, what could compel a good, God-fearing, church-going, proud mother and wife to feel the kind of hurt and betrayal to explain at least what some of these persons who happen to be employed of the government did. So when people are looking, they can say, all right, this prosecutor did this improperly or illegally. If that would, this is
exactly.
And my condolences to you and
Thank you.
Your husband and your son and your family, and to your mother who
Thank you.
did not get to see her son, her grandson, free, leaving here not knowing. I just want to express on behalf of anyone that has had a loving grandmother or mother, my personal sympathy, and for I'm certain the people that will see this.
Thank you. Well, after the appeal, we were notified on August the 6th by our attorney by phone, and then my husband and I went that Saturday to his office to see him. And after leaving there, we started really digging, and we were able to compile over the next few years what ended up to be a 12-page letter. This is a copy of the letter to the Honorable Eric Holder. There is a 13th page,
General of the United States,
who is the Attorney General of the United States, of telling him the story of Kenneth. Now, people may say they're innocent and what have you, but exactly how many write with proof to the Attorney General of the United States of America? The 13th page are exhibits. We sent him an exact, piled everything. Okay. Not everything, because God knows it's too much for one letter. And we told Eric Holder at the end of the letter we have more. But we compiled everything into a 12-page letter, with the 13th page being a list of the exhibits. The folder went down to Eric Holder, this same type folder, with the letter on this side and the exhibits on this side, clearly marked. And he had his name and address there, and we had a return label sticker there, and we sent it express mail. He did get it. Ultimately, it started out pretty good. My husband would call down there to Justice Department. They told him and refer him to the criminal division. This division had it. The person there would not ever give my husband his name, but he did say that they had received it, and he said, "We are waiting for it to come back, and then we'll send it to the executive office of what is executive office EEOC, executive office of prosecutors." That's what it really means. And so, come back from where? So during this period, the letter is dated November 18th, 2009. It got into the Department of Justice based on the Postal Service green return card on November 26th, and it was ultimately dispersed into criminal division. So come back from where? So when we went up to the jail the month of January, people are looking at us and the guards, and we even went outside to leave, and they were around our car looking, and what's going on here? So we figured out that the FBI had been there, and because they were investigating. We ultimately got an investigative number from them, and it's in this documentation.
They were investigating for
this letter
that you sent to the Attorney General. Now, after they investigated your letter, did you get any feedback from the Justice Department of whether they found that you had told them the actual facts?
I think so, because my husband subsequently called down a few weeks later and talked to the guy and said, yes, it came back. We don't know back from where, and it has now gone down to the executive office. Oh, when I have letterhead here. It is the executive office for United States attorneys. So we're thinking, well, if it came back not representative of what we had said, then why send it? I mean, what are you doing? So they are honestly investigating this. But then it came a point in time that we received feedback from the Executive Office of United States Attorneys, and they're basically telling us they don't handle this. Now, remember, this is where your prosecutor is going to come from.
They don't handle misconduct, or at least discrepancies in how they execute a prosecution.
Exactly, and these are the responses from the Department of Justice and our responses back to them. This is what this packet is. But getting back to the original letter, the letter cites points of illegalities that along with exhibits.
Could you share some of the points of illegality?
Yes. Our exhibit. Well, first of all, we talk about the state secrets. If we will remember, when Obama came in, he talked about the new state secrets policies and procedures. In other words, we're going to dispense with that. And then, so he came in talking about that, so we talked about it. And that's when your Henry Gates situation was coming into play, you know, the Boston situation.
And the policeman acted
and the
stupidly.
policeman and all that. So we call upon that. Okay, but then, and so we talk about that. But then we go into how the prosecutors willfully withheld exculpatory evidence from the defense. What this was is that that which got Kenneth there has never to this moment been filed. We were able, there have been 3 docket numbers in this case. 3. We have the dockets. They have now been erased from the federal court system. If you were to go, we have gotten from 2 reliable sources. I'm not going to name them right now, but we have gotten from 2 reliable sources that you cannot get the federal court records of Kenneth. When you look onto Pacer, which is the lawyer site where you can get motions and what have you, the first 2 case dockets are gone. Not to worry, we have copies which we've provided to the Department of Justice. And the 3rd docket, you cannot get into the material. Can't get into it. Not to worry, we have the material too. Okay, now, on our Exhibit A, and I'll have to explain this, we are, the first thing we're telling before we get into this exculpatory evidence is that on December the 15th, State's Attorney Rod Rosenstein issued a press release. This is the copy of the press release. This is his press release, and it says for immediate release, December 15th, 2005. And he's saying former Maryland NSA employee convicted of wrongly possessing classified information. Now, within this, he writes, witnesses from both the NSA and the Central Intelligence Agency testified that the classified documents, some of which were displayed to the jury in edited form, were extremely sensitive and related to the national defense of the United States. Though there was conflicting evidence of what Ford intended to do with classified information, the jury's verdict demonstrates that it was satisfied that Ford had unauthorized possession of the information.
Let me ask a question there. Now, in the trial, if I'm correct, the judge gave instructions to the jury that they did not need to have evidence of intent to convict Kenneth.
Yes.
Is that correct?
Yes.
So if they didn't sufficiently show that they had evidence that he even had the documents he's accused of having, they were instructed to convict him anyway, and yet in this document here you're saying they're saying that he did have the very evidence that they told the jurors that they didn't need to have for him to be guilty of what they said.
Exactly. And also within this, this Rod Rosenstein is admitting, he's saying though there was conflicting evidence, he's admitting that the government has given conflicting evidence. Garbage in, garbage out.
Conflicting evidence that substantiates that he had it, or conflicting evidence of whether he didn't have it at all, and some statement that he did have it. It seems to be that there are 2 opposing opinions, that he did and he didn't have it. But I know for certain for drug trials, they allow what's called phantom evidence. So you have a phantom evidence of espionage and a dissent against the phantom evidence.
But see, this is the thing. Even in a drug trial, the government presents its case in a certainty. Whether they're wrong or right, they presented that they're certain that this happened.
And there's no certainty.
This man is saying that the government is knowingly presenting conflicting evidence. And the man wrote it down. But more importantly, this part about witnesses from both the NSA and Central Intelligence Agency testified that the classified documents, some of which were displayed to the jury in edited form. You can't do that. Recently, first in 2009, in the case of USA versus Rosen and Weiss, and this is also in the letter to Eric Holder. That's why that case was dismissed, because you cannot redact or edit evidence, regardless of what the charge is. You can't edit and redact evidence. And in Rosen versus Weissman, the government was not willing to show the top secrets of the government. So therefore the case was all but lost. So the government wrote a motion to dismiss based on that. More recently, just a couple of months ago, in USA versus Thomas Drake, it was the same situation. The government wanted to redact. That was over in Maryland. The USA versus Rosen and Weissman was in Virginia. Judge Ellis. The USA versus Thomas Drake was in Maryland. Judge Bennett. The government wanted to redact the classified papers. You can't do that. And the secret agency said, no, we can't have our secrets out there. So the government had to dismiss the case against Thomas Drake. That was about 2 months ago. So they wrote a motion to dismiss the case against Thomas Drake because they had nothing to present. It's against the law. Thomas Drake was accused of 793E, the same as Ken. Rosen and Weissman were accused of 793E, the same as Ken. White. They're all white. The black guy, Kenny Ford, his stuff can be redacted. That which is used against him can be redacted, edited, and it's evidenced by what the state's attorney, the Honorable Rod Rosenstein, wrote. He wrote this. We showed this to Eric Holder. Also in this letter, and we're telling him exactly legally why this cannot be done to Mr. Ford. Also, this exculpatory evidence, that is our Exhibit B. These are the affidavits that led to the search warrants. It's 2 of them because in the first search warrant authored by FBI Special Agent Michael L. Thompson, this is the government seal. This is his name, and he's saying, I, Michael Thompson, being duly sworn, hereby states the following under penalty of perjury. This is his signature. His signature. And he's dated that January 10th. This is his signature. And he's saying, subscribe before me and sworn this 10th day of January 2004. He's describing in here where he got phone, where someone at NSA, and he even names the person. He says it's Mr. James Hopkins. Got phone calls from Tanya Tucker from a person. Michael Thompson does not describe her as or name her. He just says a person, saying that Mr. Ford was supposed to go this particular day, January 10th, and it's all in here, to the Dulles Airport to meet a diplomat. And he does say that this person identified herself as Kayla Walker. And in here he's saying that Kayla Walker's little sister is dating Mr. Ford, and her sister is terrified of Mr. Ford because Mr. Ford has these classified documents, and he's going to sell them to a diplomat, and he's supposed to go to the airport, Dulles Airport, on January 10th and meet a plane that purportedly lands at 11 a.m.
Can we talk about Kayla Walker for a second?
Yes, we can.
And who is that?
This ends up being Kayla Walker, also known as Tanya Tucker, and I'll explain why we know that. We know that through the second affidavit. But the first affidavit, I would just like to read you a small portion of what FBI Special Agent Michael L. Thompson wrote. He wrote that under the facts of the investigation, he says, on Monday, January 5th, 2004, a woman identifying herself as Kayla Walker called the NSA Associate Directorate for Security and Counterintelligence. Now, I would like to stop right here. Anybody in the listening audience, look up NSA in your typical telephone book and see exactly what you get. There is a number in there for the recruitment office, and after that, remember, NSA also stands for no such agency. They don't have any numbers listed anywhere. However, she called, according to this, and talked to NSA Associate Directorate for Security and Counterintelligence. Walker spoke with NSA Special Agent James Hopkins and advised him that her little sister has a boyfriend named Kenneth Ford and spends time at Ford's house at Waldorf, Maryland. NSA Security Office records reflect that as of January 2nd, Ford resides at this particular address, and stated that he was that he had resigned. He resigned that Friday, and he started a new job in the private sector doing the same exact thing the following Monday for Northrop Grumman. Then he wrote that Walker advised her. Walker stated that Ford very recently resigned from NSA and has classified information in his possession, which has caused both Walker and her little sister to be concerned. Walker advised that her little sister faxed one of the NSA documents to Walker. Walker read a portion of the document to Special Agent Hopkins and indicated to Special Agent Hopkins that the document was stamped with confidential classification markings. While relating the contents of the document to Special Agent Hopkins, Walker also read the name of an NSA official known to Special Agent Hopkins. Walker further stated that Ford previously worked for the U.S. Secret Service and so forth and so on. Okay, on Friday, January 9th, 2004, at approximately 1 o'clock p.m., Walker again called Special Agent Hopkins at NSA and advised that she had more information on the matter. Walker advised she was a U.S. Department of Defense contractor working on the Spa Wars project and had a top secret security clearance. Walker apologized for giving a bad callback phone number during the first call, claiming she was afraid. Excuse me, but exactly when do you call NSA or FBI and they can't get back to you, whether you give a bad number or not? She advised that Kenneth W. Ford resided at this particular address. Walker stated that her little sister spends time at this address and she is afraid for her little sister. Walker further advised that Ford planned to meet someone tomorrow, Saturday, January 10, 2004, at Dulles Airport to provide classified documents for money. Walker said Ford needs quick money and will be giving information about the people he has been spying on. Now, to have clearances, you have to have excellent credit. Walker stated that Ford had been offered money for information and that Ford has contacted a diplomat or someone like that who was flying into Dulles Airport to meet him. Walker advised that Ford told her little sister he would be away all day and that she, the little sister, thought the flight was going to arrive at 11:05 on Saturday, January 10, 2004. Walker did not know the identity of the person or persons Ford was planning to meet at Dulles or the number of persons involved. Walker advised she had no further information about the unknown persons. Walker further advised that her little sister asked Ford if she could ride along for the meeting, and Ford said no. Little sister further advised Walker that she had seen Ford reviewing the documents for this meeting and that he has a shitload of them and that they are stamped with red confidential classification markings. Now I want you all to remember that he had been seen reviewing these. Late in the evening of January 9th, Walker was advised by her little sister that the meeting may have been canceled, but your affiant has not been able to confirm this information. Walker asked her little sister if she could get the documents out of the house. She responded that she could not and that Ford would kill her. Little sister advised Walker that Ford told her little sister not to contact NSA and that if she said anything about what she has seen, he can have her family killed and make it look like an accident. According to Walker, Ford further told little sister that he can make people disappear if she reports what she had seen. Ford also said he has boxes of documents upstairs and downstairs, and that he has a safe containing documents in the closet in the master bedroom located on the second story of his residence.
Did they ever find the safe when they raided the house?
Yeah, the safe is in there, and it was left in there. Mr. Ford had a safe because as a responsible person, when he was in the Secret Service, he was issued a weapon that he had to have with him at all times. So when he came home, though he is an only child, on my husband's side, Mr. Ford has many cousins and relatives, and some of which are little children. They're still coming. So we always felt that when he came in, he would lock his weapon in his safe. So that's why he had a safe. When he resigned from the Secret Service and went to NSA, he had to turn in his weapon. So he would keep his house papers and birth certificate and what have you in his safe. And the safe was still there. That's part of the house that wasn't searched.
Although the safe is mentioned in the affidavit, they did not retrieve the safe to take it back to the Bureau of Investigation to determine whether these classified documents that he had no lawful purpose to have in his home being there.
Exactly.
Meaning that they used the safe as proof that he had secreted documents, but left the safe when it came to retrieving.
Exactly.
Huh.
And now to continue on, all of the above information from Walker is based on what she learned from her little sister. Walker has not met Ford and does not know him. Remember, in all of this, there is no probable cause. You cannot get a search warrant legally in the real world because somebody made a phone call. And he has written, I have apprised that agents of the federal government have conducted a surveillance of Ford and have determined that One, he has been driving a white 2000 Infiniti sedan, which he parks in the garage of his residence, and then they give his address. These are his crimes. And that 2, Ford was observed to retrieve mail from the resident's mailbox. His crime, that he got his own mail, not from someone else's mailbox, from his residence's mailbox. So based upon the foregoing, this man is respectfully requesting the following: search warrants for his house, and he gives the address for his car, the Infiniti, and for his 1998 Ford pickup truck. So these search warrants were issued, and he swears these facts to be true. Now, this is January 10th, and if you all will remember, Mr. Ford was supposed to go to the airport, Dulles, and meet this plane at 11:05, and perhaps after doing his little spy work and exchanging his money, then perhaps he would get back home about 1 or 1:30 or so. I showed up, and I stayed. This particular FBI agent testified in court that he saw me. Now, and he left. He leaves me, an uncleared person, in Mr. Ford's home with unclassified papers. So what has effectively happened, I don't leave until about 3:45. So what has effectively happened is that I have messed up the scenario of this affidavit. It is my opinion that that Special Agent Michael L. Thompson was going to come into Ken's house. That's why he was sitting on the side of it. Also, maybe at another time I'll tell you about what he had done to Ken's telephone. And we have proof of all of that. But to keep Ken in that house. And he was going to perhaps come in about 1 o'clock or so, when Ken was supposedly be returning back from Dulles, find this money, and then he was to secure the house and take Ken in. This is Saturday. Court isn't the nearest time to being in court would have to be Monday. He would take Ken in, secure Ken in jail, come back to Ken's house and plant this, that, and the other and take pictures. I believe, in my opinion, that was the plan, but I messed it up. So apparently, this was too good to pass up. So that's when his supervisor, Special Agent Frederick C. Marsh, this is his seal, this is his name, and this is his signature. His is dated the next day, January 11th, and he gets a search warrant for Kenneth's house. This is his signature. And he comes up with another scenario. And what he is saying is that apparently we're to scratch the Thompson one, apparently. And he comes up with another plan. And he is saying that, let me find that, he admits that there were search warrants issued the day before. He admits that here. And he says, subsequent to the issuance of the January 10th, 2004 search warrant for this to Kenneth Wayne Ford, further investigation determined the following. The individual who identified herself to National Security Agency NSA employee as Kayla Walker and reported that former NSA employee Kenneth Wayne Ford was in possession of classified documents is believed to be Tanya Tucker. He admits this. Tucker is also known by the names of Tanya Miller and Tanya L. Stewart. And he writes that Walker advised an NSA employee, he doesn't name the employee, Thompson did, that her cellular telephone number, then he gives the phone number. The records of Sprint Spectrum reflect that this cellular telephone number is subscribed to by Tanya L. Tucker, and then he gives her address in Orlando, Florida. He says that Walker advised the same NSA employee that at the time of their conversation, she was in Florida. A subsequent review of cell site information furnished by Sprint Spectrum concerning the cellular telephone utilized by Walker revealed that at the time of the conversation between Walker and the NSA employee, the cellular telephone was pinging off cell sites in Maryland. Walker advised the NSA employee that she had not met Ford and did not know him. A review of Sprint Spectrum telephone toll records for the cellular telephone utilized by Walker determined that between January 3rd, 2004 and January 10th, 2004, there were 92 telephone calls placed between this cellular telephone and then a telephone number that belonged to Ken, which is subscribed to by Kenneth Ford at his address. During a telephone call between Walker and an NSA employee on January 10, 2004, Walker advised that she was in Florida, would fly to Maryland on January 11, 2004, and meet with NSA representatives at the Homestead Studio Suites in Annapolis, Maryland, in an effort to help the NSA retrieve its classified documents. In a conversation between Walker and the same NSA employee on January 11th, Walker reported that Ford described for her highly classified information related to the identification of foreign countries he targeted while employed at NSA and how NSA tracked conversation from these countries. And then he tells on January 10, 2004, during a physical surveillance of Ford was observed driving from his Waldorf, Maryland residence to the Homestead Studio Suites in Annapolis, the same hotel in which Walker was to meet NSA employees on January 11. Ford was observed meeting with a black female who subsequently got into Ford's vehicle, a pickup truck believed to be the 1998 Ford pickup truck that is the subject of this affidavit. Ford was observed placing what appeared to be 2 pieces of luggage in the back of the pickup truck. Ford and the black female then drove to Ford's residence. Upon arriving at the residence, Ford drove the pickup truck directly into the garage, lowered the garage door. Physical surveillance established that Ford and Walker stayed at the residence overnight. Now this happened because Tanya had called Ken up while I was there, but I didn't quite know. I knew it was she. After I left, Ken called her back to see what she wanted. She wanted to use his washer and dryer because she had planned on going back to Florida on Tuesday, and she wanted to wash her clothes, and she wanted to use his washer and dryer, and she wanted Ken to help her get boxes to pack her stuff. So Ken decided to go ahead and get her and let her use the washer and dryer to be rid of her, since she said she was going back to Florida, and he would help her get the boxes the next day. Well, that day. But as it turned out, when they got back, it was after 7 o'clock, and she suggested it was late, and she could stay there the night, and she would get up the next morning to do the washing and drying, which she did. And then afterwards, on the way back, they could stop and get some boxes. So, okay, he was okay with that. And then the next day, Sunday, while he was watching the playoff games, she's washing and drying, and we, of course, my husband and I didn't know she was there. And That was the plan. But at 10 of 6, the FBI came into his house. Now I want to say right here that about 3 o'clock, Tanya decided that she wanted some shrimp. My son had already gone to the grocery store for that period. He is a bachelor. He owns his own home. He does his shopping periodically. And, of course, he had food in the house, not shrimp. She wanted shrimp. She decided to go to the Giant. And when she went to the Giant, which was 5 minutes away, it took her over an hour to get back. And my son did realize it was taking her a long time, and you figured on a Sunday, playoff Sunday at that, it shouldn't have been crowded. And the Giant was, after all, only 5 minutes away. So that's why she was over his house. So it is our opinion, because she had a classified document in her bag. Well, it was alleged she had a classified document in her bag. We've not seen it yet. There was an envelope, a FedEx envelope in her bag that showed up when the FBI opened it when they got there. And we think she met Special Agent Thompson, because remember, I had messed up the previous scenario. And Tanya was supposed to plant this document somewhere in Ken's house. And it's obvious she did not expect them to come in that day, because she had not had time to plan it. Several hours had passed, but it's obvious she had not had time to plan it. So anyway, getting back to this particular affidavit that was sworn, allegedly sworn to a United States judge, it says that a review of records maintained by the studio suites revealed that a person identifying herself as Tanya Tucker had been a guest at the hotel since October 14, 2003. And to date, the total charges for her stay are in excess of $4,875. We know that it's in way excess of that, because we looked up the cost of her particular suite, and at that time it was $128 a day. So by this time period, from October the 4th to January this is dated the 11th, we calculated, I believe, about $28,000. So he's even lying about this. To date, total charges for her stay are in excess of $4,875. Tucker furnished the hotel with 2 addresses, and he gives the addresses in Florida. Hey, I may as well give you the addresses. 2152 West Oak Ridge Road, Orlando, Florida, and 5214 Aventura Boulevard, Orlando, Florida. And it says that the Aventura address is identical to the address to the subscriber to the cellular telephone that Walker is using. Then the FBI agent Frederick C. Marsh writes down, a review of criminal history records reflect that Tucker has a number of arrests, including arrests for driving while suspended, criminal trespass, criminal damage to property, larceny, multiple counts, forgery, credit card fraud, passing fraudulent instruments, shoplifting, aggregated stalking, aggregated assault with deadly weapon, battery, contempt of court, and robbery, among others.
Now, those are her charges.
These are charges that the FBI wrote down. We found more, including a charge for having sex with a dolphin, including a charge for being in jail and ordered by a judge not to ever own a credit card. She testified to court that she owns a credit card. And
she claims to be, if you don't mind showing the picture and holding that up on the table there, she is she claims to be a graduate of FAMU, Florida A&M University in Tallahassee, Florida.
Well, she told my husband and myself that she had 4 degrees at that time. And also in here, let me find it. Special Agent Frederick C. Marr says she goes around saying she's a lawyer. I'll have to find that. It says, investigation of Walker has determined that while Walker has never wavered from her allegation that Ford is currently in possession of classified materials, Walker has made a number of inconsistent and or false statements concerning her whereabouts, her activities, and her apparent relationship with Ford. Let's see. It says, for example, in addition to the above information, checks with the Defense Security Service have been made to determine if anyone known as Kayla Walker, Tanya Tucker, or Tanya Stewart possess a security clearance. According to the DSS, no persons known by any of those names has a clearance.
Did you find any information for how she was supporting herself or paying her bills?
Yes. In this suitcase where this document was,
the document that was used to indict or falsely accuse your son of espionage.
Well, we'll say an envelope because we never saw the document. See, let me tell the listening audience that there is no evidence in this case. There is not one person, there is not who has seen Ken remove documents from NSA. There is no video, there is no audio of any of this. There is not one picture, not one videotape of documents in Kenneth's house. We have testimony from the recording agent during this search that the pictures that they have of Kenneth's work were taken 2 to 3 days later at an FBI facility. Not in his home, in an FBI facility. 2 or 3 days later. There is not one picture. The best picture they have that they used in court was a small box taken from Ken's family room. The picture is taken from Ken's family room to his kitchen. There's a box sitting on the floor, a small box, and it is at a 25-foot distance? Would you say that? The picture is at a 25-foot distance of a box, and the prosecutor points to the box. This box contains classified documents. That's their best evidence.
But there's no picture of what's in the box or anything else.
Nothing. And also there is evidence testified to in court by Special Agent Michael Thompson that Kenneth's fingerprints are not on any of the documents that were seized from his house. Now, I know my son is exemplary, but he does make fingerprints. Nobody has ever talked of him wearing gloves. And remember, Tanya Tucker said that he was reviewing the documents and that he had boxes and boxes. But yet, the special agent testifies that Mr. Ford's fingerprints were not found on any of those documents. There is one fingerprint of Mr. Ford, and that is of his baby finger on his right hand, and that was when someone handed him in his house the document for him to read. They claim they found this. This supposedly was in her suitcase. They handed it to him. When he reached out for it to look at it, they snatched it back, and that's how his print of his baby finger got on the document. That was testified to in court by Special Agent Michael Thompson. There is no evidence in this case. Absolutely none, because it didn't happen. And I'll break back in when I find the part where this man, Special Agent Frederick C. Marsh, has said that she goes around identifying herself as a lawyer, and I'll find that. In the meantime,
I want to come back to her and just discuss briefly this picture of her. Does this look authentic to you?
It does not look authentic to me, because it's probably something the FBI made up, or because exactly when is she going to college? Between all these convictions and arrests, we found a document, and we asked our attorney to look into it, and we know he did, but he didn't share it with us. In May of 2003, Tanya L. Tucker is incarcerated, and she is to be incarcerated until 2007. However, in October of 2003, she's here in Maryland. Even this says that. They have her staying at the home. How does she get 4 years out of jail?
I want to ask you a question. You came of age during the 60s.
Yes.
How well do you remember the assassinations of Malcolm X or Martin Luther King, or the fights between the Black Panthers and police? Are you familiar with Cointel Counterpro? Have you? I'm
not familiar with that name. I'm familiar with the 5 assassinations that you just mentioned, but I'm not.
Does any of what you're looking at, that you've experienced in relationship to your son, seem like anything that you may have heard other people discuss in relationship to frame-ups to the police?
Yes, in the 60s, yes, and 70s, yes.
So you had heard of these things, but never thought they'd happen to you or your son? I
would have never, had I not seen these affidavits. And by the way, these affidavits have never been filed. This is what brought Mr. Ford there. This is what the search warrants are based on.
So the affidavits that were written to justify a search warrant of his car or his vehicles and his home were never used in a court of law to have him charged.
Exactly. So they have never been filed to this date, and I have the docket page to prove it.
So where is the affidavit or documentation that would bring him into the court of law, if not these two that you have?
Mr. Ford was sitting in court for nothing. Now let me tell you this. We don't get these affidavits for 20 months. I don't know if you can see this, but there is dated August 1st, 2005, U.S. Attorney, and there's a phone number. This is the United States Attorney. We got these affidavits because Ken went up to his attorney, Spencer Heck's office, and Spencer said these were faxed to him. Now that's what he said. We have since come to believe that by this time Spencer is in collusion with the prosecutor. We have come to believe that if it hadn't been for that moment, that time, if God hadn't been on our side, he would not have given Ken these affidavits. These affidavits, and I'm going to show you something else while we can prove they're phony and false. But these affidavits, 20 months later, this happened to Ken's nightmare started on January 11th, 2004. This is dated August 1st, 2000. We don't know what has happened. We don't know anything. Ken gets these affidavits, and this tells the story. I immediately, in the second affidavit, okay, the first thing I'm wondering is why are two affidavits needed? And somehow I knew that I messed up the events of the first affidavit by showing up to visit Ken. I knew that. I just knew it. I knew it before we got the affidavit. I just felt it. And then when we got the affidavits, it confirmed it. But in the second affidavit for Frederick C. Marsh, remember, he gives the phone number. He gives additional dates that this woman was to have called. He gives the phone number. He tells us that it's with Sprint. He tells us of the satellite of the satellites being utilized, the pings. He's very detailed, very nice information. So I told our attorney to contact Sprint just to see if he could get these phone records. He was very resistant to contact Sprint. He was very resistant. But I kept on. This is hacked. I kept on and on and on and on and on and on and on day after day because I'm not understanding this at all. So one day, these telephone records come in the mail. They just come. So we go over it was a stack of them, and I wanted from October let me back up. I wanted from October the 1st to January 31st. And so eventually he called and he said, I contacted Sprint and it will be $107 for the telephone records and they need a subpoena. I said, well, you take care of the subpoena and I'll send you a check for the $107, and I did. So and he sounded a little odd to me. And so about 2 weeks later, they just arrived in the mail. So we went back to the affidavits, and this is what I wrote for Eric Holder in the Department of Justice about the subpoenaed cell phone records. Please note the dates of the alleged calls are January 5th, January 9th, January 10th, and January 11th, 2004. You will be looking for calls designated Waterloo, Maryland, or Fort Meade. These are the telephone companies' destinations for NSA. You will find none. The sworn FBI affidavits are fabricated with the details of the alleged cell phone calls given in the Thompson affidavit as expounded upon by the extensive details of the alleged calls in the Marsh affidavit. The attached cell phone records make it glaringly apparent that Tanya Tucker is a confidential informant. To date, this has never been disclosed to the defense by the government, nor was it disclosed to the jury. When you go through the telephone records, each one of these dates are indicated in yellow and underlined and highlighted. You will not find a call that designates Fort Meade or Waterloo. These are the telephone company's designations for NSA. And each one of these dates, this is her record. And at some point, she changed her telephone record because we have some that say Tanya L. Tucker. And then she became a doctor. And she told the telephone Sprint she was Dr. Tanya L. Tucker. And this is her phone number as sworn to by a special agent.
Were you ever able to confirm whether she was a graduate of FAMU?
No,
Do you think that she's telling the truth?
No, Tanya is just about illiterate. When you talk to her, you'll see that. And so each one of these dates are highlighted. There is not any calls. These affidavits are fabricated. There are no calls. Now, how do I know she's a confidential informant? By the dates, she has always been depicted in trial and everything, even at the sentencing, as a tipster, as a friend of Mr. Ford. We don't know these people. It was asked to by Frederick Michael L. Thompson was asked, did he know Tanya prior to this? No. Tanya was asked, no, I don't know Michael. I don't know these people. But yet, until they don't know them until they come into the house. These affidavits are written before they came into the house.
I want to interject this and say this because we have a point where we bring this to a close.
Mm-hmm.
I believe that you've more than adroitly shown that there isn't really a case.
There is no case.
That there is nothing but innocence for Mr. Ford.
Mm-hmm. Mm-hmm.
In your summation, I would assume there's a major lawsuit that
Mm-hmm.
you, your family, husband, and son would have.
Mm-hmm.
How would you envision seeking legal redress if you could get into a court of law?
We need a lawyer, and the case is easy because we have all the documentation needed. We have the evidence. The Justice Department, you can tell by their answers back to us, they know when we get into court, they don't have an answer. They do not have an answer. Mr. Ford has been railroaded, framed by the criminals who work for the Justice Department. This is a major lawsuit. Mr. Ford has lost everything. We are ending up 8 years. At this point, Mr. Ford, I really don't even want to say the amount of money that he would be earning, let alone his career has been severely damaged. His career contacts, the knowledge, the additional knowledge he would have gained from all of this is tremendous. His punitive damages are tremendous. When this happened, Mr. Ford, who is not the biggest of people to begin with, immediately dropped 37 pounds. Immediately, within a month. And, I mean, when we get into court, we need a lawyer. We have everything here that you need. Eric Holder knows this. Also, this has the potential of these people going into jail. And for any lawyers out there, Franks versus Delaware will throw this whole thing out. Decided in 1978 by the Supreme Court in a 7-2 decision. That will throw it out. Let alone all the other precedents we have. USA versus Rosen and Weissen will throw it out. USA versus Thomas Drake will throw it out. We will win this. We need a lawyer. And we like to file, and we have to file in the Fourth Circuit, so we're talking about D.C. or Virginia, preferably D.C. Maryland, unless you get Judge Bennett, who had Thomas Drake. We have things that will really put these people in There is no way that the prosecutor didn't know this was illegal. There's no way Prosecutor David I. Salem knew it was illegal. FBI Special Agents Michael L. Thompson and Frederick C. Marsh knew it was illegal. It is no way. We have the dockets to show it. We have the dockets to show it of all three cases. It's no way that Judge Peter Massetti did not know this was illegal. By the way, Peter Massetti suppressed the first affidavit, Michael L. Thompson, at the suppression hearings in August of 2005. And on the morning of the trial, he suppressed the Marsh affidavit. So why is Mr. Ford sitting in there? We have shown Eric Holder where their own DOJ regulations were violated. These are the regulations for national security issued by the United States Department of Justice. And it tells in detail what's supposed to happen. If this case were to be brought, it would have been brought by the United States Assistant Attorney General at the time, who was Alice Fisher. It would not have been brought by some half-eaten up prosecutor in Greenbelt, David I. Salem, who's been there since 1983 in the same position.
Thank you. Mrs. Gloria Ford.
Thank you.
On behalf of Dignity, I thank you for your courage, for your prophetic witness for justice, not just for your son, but for all victims of the criminal and justice system, for all the mothers who lost children in Iraq and Afghanistan and interrelated wars. We want to bring this to a close. So I thank you. I hope that this film reaches the right hearts and legal minds to provide a legal redress and reparations, both spiritual, financial, and otherwise, to you and your family.
Thank you.
God bless you, and we'd like to thank our videographer, Jocelyn Lawrence, for her wonderful assistance.
Thank you very much.
Thank you.